Next matter does not have a docket number. It's a matter regarding search warrant in the case of Commonwealth of Karen Reed.
Good morning, Your Honor. Excuse me. Good afternoon, Your Honor. Robert Cosgrove for the Commonwealth. Good morning.
You got a
Mr. Clerk.
phone. You got to take it outside the courtroom, please. Hi, Mr. Cosgrove. Hi, Mr. Herbalist. How are you?
Good afternoon, Your Honor. Attorney Ben Herbalist for Ms. Reed.
Okay.
Good afternoon, Your Honor. Alan Jackson on behalf of Ms. Reed's interests.
Good afternoon.
Nice to see you.
Nice
Good afternoon, Your Honor. Evan Wolk on behalf of Ms. Reed.
Okay. Good afternoon. Let me just talk you up at sidebar just for a second. Mr. Jackson, the floor is yours. Go right ahead.
Thank you, Your Honor. I appreciate the time and the court accommodating us this morning for the, or this afternoon, I should say, for the purpose of talking about what we filed. I'm going to try not to be repetitive, but I do want to address in no small part, the opposition that the Commonwealth has filed. And really, our motion comes down to a single promise and a single breach of that promise. The promise was independence. That's how we got here. Mr. Cosgrove was appointed on the promise of complete independence from the Norfolk County District Attorney's Office. And on February 19th, in this courtroom, the special prosecutor, I think, slipped and admitted in his own words that the promise had been broken. Everything else in the Commonwealth's opposition, as I read it, is an effort to sort of talk past that fact. And I want to address that in no small part in some order. And I want to start with the standing issue. That's where the Commonwealth leads in their opposition, and I want to lead in my response to that opposition. The Commonwealth's lead argument is basically the conflict, in as much as it might exist, it belongs to Aidan Kearney, not to Karen Reed. It's a clever argument. I can hand it to Mr. Cosgrove for leading with that because it is clever, but it's also wrong. The warrant doesn't exist in the abstract. It exists because the Commonwealth has advanced a theory, a stated theory on the record, that basically Karen Reed potentially engaged in some sort of witness intimidation. That's the foundation for what the Commonwealth has suggested precipitated the warrant in the first place. And it's on the strength of that, what we believe is a very flawed and a false theory. They went to a judge of the court and they said, we need a warrant naming her, Karen Reed, and they seized her phones. And today, in this moment, the special prosecutor is actively litigating to keep her phone away from her, out of her possession. So in terms of standing, when the Commonwealth stands up and says Karen Reed is basically a stranger to this conflict, she has no standing, this is Aidan Kearney's conflict, that's simply not true. I'd ask the court to inquire a few questions of Mr. Cosgrove. Whose phone is it that's at issue? Whose name is on the warrant? Whose privacy is on that device? That's not Karen Reed borrowing Mr. Kearney's grievance. That's Karen Reed asserting, in the most direct way that she possibly can, her own interests that the law recognizes. The interest in her property, which the government seized and is improperly holding. The legal standards and why we're here. Let's be clear about what the governing law is at the outset. Because the entire Commonwealth's opposition depends on the court and in hopes of the court applying the wrong legal standard, which I'm sure it is not want to do. The right one is in place. When the right one is in place, the entire argument by the Commonwealth falters. The rule for prosecutorial disqualification, and I say that with an emphasis on the word prosecutorial because I'm going to get to a point that Mr. Cosgrove cites in his moving papers that is incorrect citation and incorrect application of the law. The rule for prosecutorial disqualification in this Commonwealth is told to us by a couple of cases that we cited in our moving papers and the court has in front of it, PISA and Ellis. And it's not ambiguous in the least. PISA versus PISA versus Commonwealth deals with prosecutorial conflicts of interest that are treated with absolute strictness. And the words matter. No showing of prejudice is necessary by Ms. Reed at all. The court does not weigh whether actual harm resulted. It does not weigh whether actual prejudice exists. We don't have to show any of that. The law does not ask whether the conflicted party, in fact, changed any outcome. We don't have to show that. And Ellis completes that rule by saying that a prosecutor's discretionary choices have to be, and this is the important part of that language, completely and utterly unaffected by any private interests in fact or, and this is the big whopper, in appearance. It's those two words that I want to focus on for a quick second. In appearance. That phrase is the whole case. The law does not ask whether the special prosecutor, whether Mr. Cosgrove was actually influenced by Mr. Morrissey or anybody else in the Norfolk County District Attorney's Office. It asks very simply whether the public looking at this arrangement can have utter confidence that he was not in any way influenced by the DA's office. In other words, the law asks a very, very clean question, Judge Doolin, and the answer is very clearly as clean. It is no. The public cannot have that confidence. And I ask the court to just hold that law in the back of its mind for a second as I talk about the next point of the argument, which is the actual indication, the evidence of the breach of that promise. And this is because of the facts of the case. There is a breach because of the facts, and the facts are not very friendly to Mr. Cosgrove's position. And they're also not in dispute because they came right out of the special prosecutor's mouth. On February 19th, from the podium, Attorney Cosgrove told the court that he would basically sit down with the district attorney's office. He was going to go through all of their options. They would weigh the pros and cons of all their options and discuss those pros and cons and then get back to the court in due course. His actual language is this, and I'll quote him. Quote, "I'd like to take some time to look at Judge CHOPT's decision and to meet with the district attorney's office, the Norfolk County District Attorney's Office. I intend to do that within a week or so and discuss with them our various options. And are we going to give the cell phone back? Are we going to move for reconsideration? Are we going to file a notice of appeal? And when I've done that, I'll get back to you as soon as possible." End quote. Those personal pronouns and the possessive pronouns used in that phraseology, in that paragraph, are not of insignificance. Who is the we? Who is our options? Who's the our in those sentences? Obviously, it's in perfect context. It's Mr. Cosgrove, and it's the Norfolk District Attorney's Office. In an unscripted and what I would consider to be a pretty unguarded moment, Mr. Cosgrove betrayed exactly what's going on here and who's really prosecuting this case. And I put prosecuting in quotation marks, but who's advancing or forwarding this case against in terms of the search warrant against Miss Reed. He isn't investigating Miss Reed. They are investigating Miss Reed. He isn't holding her phone. They are holding her phone. And he said the quiet part out loud. They're improperly holding the phone together because they're coordinating together. And those are his words, not my words. According to Mr. Cosgrove, he could not and was unwilling to independently make any decision in front of the court what to do about Judge CHOPT's very unequivocal order to return Miss Reed's phone unless and until he met with the district attorney's office. He explained on the record what needed to happen before he could make that decision. And I'll just repeat it very quickly. Are we going to give Miss Reed's cell phone back? Well, the unanswered part of that question is, I can't make that decision, Judge, without speaking to the DA's office to find out what they want to do. Number two, are we going to move for reconsideration? Who's we? Him and then the district attorney's office. That's who he was referring to. The unspoken answer to that question is, I don't know. I got to check with the DA. The third question he posed, are we going to file a notice of appeal? Again, the unspoken answer was, I can't decide that, Judge, not today, because I need to first sit down with the DA's office and figure out what our various options are. It couldn't be any clearer. This is with the completely walled off Norfolk District Attorney's Office, the conflicted office, the office headed by a self-described victim of Miss Reed, Mr. Michael Morrissey. He was the authority Mr. Cosgrove admitted he needed to go to before he could make any other decisions. And there's no other way to read his words. The fact is, he was not authorized, obviously not authorized to make any strategic decision about Miss Reed and her phones until he got prior approval from the very office that was the subject of the conflict, and that's the problem. It's not a good look for the DA's office. It's not a good look for the Commonwealth. It's not a good look for Mr. Cosgrove. And appearance, when I use those words guardedly, it's not a good look because appearance means everything in this case, as we'll see. So Mr. Cosgrove, in his moving papers, he sees the problem, obviously. He's a very intelligent gentleman, a very good lawyer. He sees the problem in the accidental admission, and so he tries for an escape route. His claim now is, no, I was just notifying, I was indicating that I would notify the DA's office about what I intended to do. Except, Judge, that's not what he said. He said, I can't decide until I meet with him and we discuss our various options. That doesn't sound like informing anybody of anything. Certainly doesn't sound like informing anybody of a decision that's already been made. I think the court would agree with that. Rather, it sounds like a conversation inviting everybody to weigh in. Everybody is invited to the table. Let's talk about strategy. Then, Judge, I'll get back to you. Mr. Cosgrove actually showed us what's really going on behind the closed doors that we suspected all along. So who's really advancing this case? Maya Angelou once said, when someone shows you who they really are, believe them the first time. That is a poignant and pointed statement that I refer the court to just to say, if someone says something in an unguarded moment, you got to sort of put some stock into it. You got to believe them.
What are you looking to disqualify Mr. Cosgrove from? Any involvement in the Reed's cell phone issue?
Yes.
Or also, I mean, you shouldn't, do you believe that you have standing in the case of Commonwealth versus Adam Carney?
So that's a very good question, and I wrote in my notes. The judge is going to ask you, what do you want me to disqualify him from?
That was pretty good.
That is the question. It really is, Judge. Yes. In answer to your question pointedly, he should not, Mr. Cosgrove, and like I said, seems like a kind gentleman, very good lawyer, but he cannot advance the case having anything to do with Karen Reed. Why? Because the investigation as it is for whatever that investigation is, the only insight I have, the only crystal ball I can rub has something to do with this search warrant. So He should have nothing to do with advancing the search warrant. He should be removed altogether because the DA's office is removed altogether. And if, in fact, to answer the next question the court might have, if, in fact, there's another special prosecutor that were to be assigned to this case, God forbid, to complicate matters more, that person should have no communication, no contact with Mr. Cosgrove, nor the Norfolk County District Attorney's Office.
And who should appoint that person?
That's the $64,000 question, Judge. I don't believe that person can be appointed. I believe that this has run its course and that the District Attorney's Office was supposed to do what it wished to do by hiring an independent special prosecutor. Unfortunately, that independence was magnificently breached, not in a small way, in a big way, in the biggest of ways. And so I think the District Attorney's Office is not in a position to say, okay, well, I'll do it again. I'll take a mulligan on the first one, and I'll do it again and appoint a second special prosecutor. That search warrant should be dead on arrival because Judge CHOPT said the phone has to be returned. Okay. The only reason that Mr. Cosgrove is even following this thread, pulling this thread, is in no small part. As a matter of fact, I would say it's in almost total part because the Norfolk County District Attorney's Office did not want that phone returned.
Okay, let me call upon Mr. Cosgrove.
Of course.
Yeah, Mr. Cosgrove, go right ahead, sir.
Well, Your Honor, let me begin where Mr. Jackson began with the discussion of standing. And Mr. Jackson made a wonderful argument that his client has standing to litigate the possession of her telephone. He made a terrific argument that she has standing to challenge the search warrant, but I heard no argument as to what standing she has to raise the alleged conflict of independent counsel, because there is no conflict. Obviously, as I pointed out before, the district attorney just went through 2 trials with Ms. Reed. They were not conducted by a special prosecutor with the one exception of the special prosecutor for the second trial, Mr. Brennan, who worked hand in glove with the personnel from the DA's office. So it seems to me, Your Honor, that Ms. Reed has no standing because there is no conflict. Even if I were consulting with the DA's office on my every move, which I am not, I don't see that there would be a problem. I have yet to hear what Mr. Morrissey's personal interest or conflict is in this case. It was represented in the papers that were filed that he was a victim, and I heard Mr. Jackson describe him as a self-described victim. If I can use the word describe twice in one sentence. I don't know when or where or if he actually made that statement or what the context was, but certainly there has been no indictment that I am aware of or charge or whatever listing Mr. Morrissey as a victim in any way of this case. I have to say, as I listen to Mr. Jackson recharacterize my comments, I can't make that decision. I can't decide that. They do seem quite damning. The only problem is those aren't the comments that I made. I made the comments that I made. They're a matter of record. They were quoted in the initial filing. They were quoted in my filing. I submitted an affidavit explaining what actually happened. The credibility of that affidavit is, of course, for Your Honor, and I'm not going to argue it. I will only say about Pisa and Ellis that if Your Honor looks at the facts of those two cases, they are totally divorced from anything that's before Your Honor today.
What was the issue with Ellis? I just read Pisa when Mr. Jackson quoted it. What was the issue on Ellis, the refusal?
If I remember it correctly, Your Honor, and it's been a while since I've read it, it had to do with some illegal behavior by police officers that the district attorney was involved with. But I apologize for not being more on top of it, but I will take a look at it, and if you wish, file something.
I'll read the case, but I was just curious.
I do want to comment on Mr. Jackson's response to Your Honor's question, which he apparently was well prepared for and anticipated. Are you asking me to disqualify Mr. Cosgrove on the Kearney case or just on this matter? And I think the correct answer, Your Honor, is it really doesn't make any difference, because if Your Honor finds that I have an ethical conflict of interest and can't serve in this case, I think that counsel for Mr. Kearney will be in court tomorrow morning waiving your decision, saying the Commonwealth has had a full and fair chance to argue the situation and it should be applied res judicata. So I think that's going to be the bottom line, one way or the other. Right. Finally, Your Honor, I'd like to comment on the credibility of the other side in this case. My attention was recently given to a video recording of the March 18th, 2025 second trial of Karen Reed. And I observed the video on the internet. Therein, a justice of this court made the following oral findings, and I'm going to quote them, and I'll submit an affidavit upon the completion of doing so, because I'm going to skip over a lot of factual details that aren't particularly relevant here. In open court, Judge Cannoni said, based on all the evidence, I conclude that the candor required by all lawyers has not been demonstrated here. I find there have been repeated misrepresentations made to the court by defense counsel, and I conclude that they were deliberate. They were made in sidebar, in open court, and in pleadings. And after going through some of the details, she says, I find that there was a material misrepresentation and that it was deliberate. Candor with the court is essential. It's the bedrock obligation of all lawyers who appear in this court and all courts in Massachusetts. Those comments were made with respect to Mr. Jackson and the colleagues from his firm who filed the motion and affidavit and did the oral argument before the court today. And I would ask the court to consider that finding with respect to the credibility of the defense findings. And I will close with the words of Mr. Jackson, when someone shows you who they are, believe them the first time. I'll submit this to the court, and I have a copy for.
Thank you. Just confirm that.
Sure.
Yeah, just grab me the book. All right. Mr. Jackson, I take it by the fact that you've risen that you wish to respond in some way.
I would like very briefly
No, go ahead.
to speak
Go
to a
ahead.
couple of issues. I find it rich that a member of the bar who doesn't like what his own facts represent decides to take a personal shot at opposing counsel. That's I think that's beneath Mr. Cosgrove's dignity. It's certainly beneath the court's dignity. The court doesn't have any idea, because it wasn't sitting in the courtroom along with Judge Cannone, what the circumstances of those comments were. And certainly Mr. Cosgrove has absolutely equally no idea what those comments were. And it's offensive, but it also is very telling. It's extraordinarily transparent. If you don't have the facts on your side, then you argue the law. If you don't have the law on your side, then you argue the facts. And if you don't have the law on your side or the facts on your side, just attack opposing counsel.
I thought you were supposed to bang the table.
I think so. Exactly.
That was what it was.
Try to make it as loud as you can. And
Yeah.
with
That was
his-
the old saying anyway.
Yes, exactly. And I
Right
think
ahead.
everybody in the courtroom can see that. It's a little bit of an act of desperation. And I appreciate the cleverness and the desperation that Mr. Cosgrove shows, but it is of no legal moment for why we're here today. So no, to answer the court, once again, I am not suggesting I take no position on Mr. Cosgrove's further investigation or prosecution as it relates to Aiden Carney. That is not my position. He is not my client. But what I am concerned with is his position in terms of the search warrant and any further investigation into Karen Reed. And I find it almost nearly shocking, if I can use that word, that Mr. Cosgrove would stand up and say, there's no conflict.
Go right ahead.
Even were I to consistently consult with the Norfolk County District Attorney's Office, that would represent no harm. There's no big deal. Your Honor, if it was no big deal that he consult with the conflicted Norfolk County District Attorney's Office over the issues attendant to witness intimidation that is focused on Aiden Carney and concomitantly focused on Karen Reed because of what he says may have been an agreement between and among them, then the question is begged, why was he ever appointed in the first place? If there's no issue with conflict, why was he appointed? Why is he getting paid taxpayer dollars? He was appointed because Mr. Morrissey recognized that there was a potential conflict because Mr. Morrissey is a titular victim, a potential victim of the very allegations he's investigating. And now Mr. Cosgrove is proverbially in bed and has been with the district attorney's office. That's the issue that we've got. And Mr. Cosgrove's affidavit is equally flawed as his reasoning on that argument. His affidavit does not cure the problem. His affidavit is the problem. Consider what it actually offers. It's a sworn assurance from the very person whose assurance of independence is in question by his own words. The court doesn't have to find, and I'm going to step up a little bit from the personal attacks and invectives. I don't think they're appropriate in the courtroom, and I'm not going to lower myself to engaging in those. The court doesn't have to find, at the end of the day, that there was actual prejudice or that there is actual prejudice against Ms. Reed or her interests. The court does not have to find that there's actual bad faith on the part of Mr. Cosgrove. Neither does the court, or neither does the law, require that the court find that anyone lied or anybody was mendacious. I'm not suggesting that. And the court doesn't have to find it. Or that he, in fact, made any decision that was, on its face, corrupt or conflicted. The court doesn't have to find any of that. The law is very clear, Judge, and that's why we're standing before you. It requires one thing. It requires independence in fact and in appearance, and that has been breached. By his own words, the special prosecutor, Mr. Cosgrove, has indicated that the appearance of independence is gone. And for those reasons, the only remedy as it pertains to Ms. Reed's interests is to disqualify him from any further contact or connection with the search warrant and any investigation related to witness intimidation.
Okay.
Thank you.
Thank you very much. Thank you all for being here. I'll take it under advisement.
Thank you, Your Honor.
Thank you.
Appreciate the time.
Thank you, Your Honor.
Your Honor.